Hello again, everyone. So here is your last but not least lecture for psychology and the law. I hope you've been enjoying this class. I certainly enjoy teaching it. So today we're going to continue talking about the traditional and non-traditional prosecutions, and we're going to talk most specifically about what is the purpose of a trial to start with. So Miller and Boster in 1977 identified three images of the trial. The trial as a search for the truth that assumes the truth can actually be found, right, be ascertained, and that it will emerge from the confrontation of conflicting facts. It also assumes that judges or jurors can put aside their prejudices and decide the case with dispassionate analysis of the arguments and evidence. It can be really difficult to actually meet this ideal. Can also do the trial as a test of credibility. This acknowledges the facts and evidence are incomplete and biased. Judge or jury must weigh in and evaluate the truthfulness of the opposing sources. Unfortunately, both judges and jurors can make unwarranted inferences. And then the trial as a conflict resolving ritual. This provides a mechanism to resolve controversies to create the sense that justice is being done. So what are the steps in the actual trial process? So in terms of the preliminary actions, we've already talked briefly about discovery, and this is that pretrial process by which each side tries to gain vital information, for example, police records, about the case that will be presented by the other side. Then you have the veneer that we've talked about before, that drawing that panel of prospective jurors from a large list, usually based on voter registration, lists of licensed drivers, as we've talked about. And once the veneer for a trial has been selected, then you have that voir dire that we talked about, where psychologists may be involved to help select eventual jurors. The trial begins with opening statements, where lawyers for each side are permitted to make these statements that are not part of the evidence, just overviews of the evidence that will be presented. The prosecution or plaintiff usually goes first, the defense's opening follows immediately after, or the defense can choose to wait until it is their turn to present evidence. After opening statements, the prosecution or plaintiff calls witnesses. Each witness testifies under oath with the threat of a charge of perjury if they fail to be truthful. Each witness undergoes direct examination, cross-examination, redirect, and recross. After the prosecution's or plaintiff's attorneys have presented all their witnesses, it is the defense's turn. Each witness undergoes direct examination, cross-examination, redirect, and recross, in this case as well. After both sides have presented their witnesses, one or both may decide to ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by earlier witnesses. Once all the evidence has been presented, each side is then permitted to make closing argument or summation. Typically, the prosecution or plaintiff gets the first summation, followed by the defense, after which the prosecution or plaintiff responds. The final step in the jury trial is for the judge to give instructions to the jury. In some cases and in some states, instructions will precede the closing arguments. So the judge informs the jury of the relevant law. The judge also instructs jurors about the standard they should use to weigh the evidence. And with criminal charges, the jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. So think about that standard we talked about way at the beginning of the semester. In a civil trial, the preponderance of the evidence is necessary for a finding in favor of one side. And preponderance, again, is 50% plus a feather. When the jury has reached its verdict, then the foreperson informs the bailiff, who then informs the judge, who reconvenes the attorneys and defendants, or the plaintiffs in a civil trial, for announcement of the verdict. So there are advantages to traditional prosecution, just advantages to which side of the case in this way that trials are carried out. So the advantages for the prosecution is that they are the first to address the judge or jury, so they have that primacy effect. They have the full resources of the government. They present evidence first before the defense. And at the end of the trial, they get to go first and also gets the chance to offer a final rebuttal to the defense's closing argument. There are, of course, also advantages to the defense. They don't have the burden of proof. That's on the prosecution. They have to prove the defendant did this. Remember, innocent until proven guilty. The prosecution has to turn over all that exculpatory evidence to them during a discovery. The defense may have more opportunities than the prosecution to remove potential jurors without giving a reason during that voir dire process. Defendants who do not take the stand as witnesses on their own behalf, they don't have to do it, and so they can protect themselves in that own way. And defendants who are found not guilty can never be tried again for that specific crime, and that is called double jeopardy. Now, in terms of sentencing, if the defendant in a criminal trial is judged guilty, a punishment must be decided. In most jurisdictions, a trial judge decides the punishment. In a 2004 decision, Blakely v. Washington, the U.S. Supreme Court ruled that judges may not increase defendant sentences on the basis of what they perceive as aggregating factors, so circumstances that seem to make the crime worse. So the court reserved those type of determinations for juries. So in a handful of states, sentencing is done by jury. In cases involving the death penalty, jurors, rather than judges, do decide that sentence, and that's from Ring v. Arizona. Now, what happens if you are unsatisfied with the verdict? Well, there's an appeal process or an appellate process. Any defendant has the opportunity to appeal a verdict to a higher level of courts. Appeals are also possible in virtually every civil suit. For an appeal, the appellate judges read the record, which is the trial transcript from the first trial. They read the pleadings, the motions, and accompanying documents filed by the attorneys. And they read the briefs, which are written arguments from both sides about the issues on appeal, and then decide whether to overturn the original trial decision or to let it stand. Appellate judges rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of that verdict. What they will reverse, it's usually because they believe the trial judge made some sort of procedural error, like allowing controversial evidence to be presented that shouldn't have been. If a verdict in a criminal trial is overturned or reversed, the appellate court or appeals court will either order a retrial or order the charges be thrown out. In a civil case, an appellate court can let the decision stand, reverse it, so rule in favor of the side that lost, or make some other changes in the decision and remand or return the case to a lower court for reconsideration. Now, what are sort of the modern adaptations that are kind of leading us to the courtroom of the future? One is video conferencing that permits live two-way video and audio communication. This can be especially helpful in the case of children or victims of crimes such as domestic violence, sexual assault, so that the victim does not have to be in the courtroom with the other. Electronic and digital evidence can also be used now. You can use computer animations and simulations of the crime to kind of help jurors understand what went on. And virtual environment technologies that allow observers to experience a recreation of events as if they were present when it occurred is sort of a next wave of the future, using that same VR technology that you might have on your video game console or your cell phone. So what are the alternative ways? What are these alternatives to traditional prosecution? Most cases are resolved through negotiation or that alternative dispute resolution, ADR. Very few cases are actually settled in trials. In 2009, only 1.2% of federal cases were decided in a trial. In 2002, only 4.7% of criminal cases were involved in a trial. Most cases are done, again, either by plea bargaining or by negotiation, without the assistance of a third party sometimes as well. Negotiation might be formal, as happens when, for example, a management and union representatives negotiate a labor contract, or it can be informal. There's a process called collaborative divorce, where the people just work together to lay out custody and whatnot. Arbitration is one of these forms of ADR. So when the parties agree to binding arbitration, they agree to accept the decision of an arbitrator. There's also non-binding arbitration, where if one of the parties is dissatisfied with the arbitrator's decision, they may ask that the case be tried before a judge or jury. Arbitration uses a trial-like process. The parties present do present evidence and argue the case, and then the arbitrator makes a decision. In recent years, however, arbitration has been criticized for being overly formal and time-consuming. You can also have a summary jury trial, which is like a conventional jury trial, but shorter. So lawyers tell juries what the witnesses would say if they were present, rather than calling the witnesses, which takes time. The lawyers argue the case and try to answer jurors' questions about the facts. The judge tells the jury what the law is and tries to answer jurors' questions about the law. The jurors then deliberate. And in recent years, verdicts from a summary jury trial have become binding and enforceable. This process educates the lawyers and clients on how a conventional jury might view the facts in the law. Once educated, lawyers and their clients are more amenable to settling the case. Mediation uses a neutral person, the mediator, to work with litigants and their lawyers to achieve a settlement. The mediator does not have the authority to decide the controversy, but rather acts as a facilitator, meeting with each party in an effort to broker an agreement. People often prefer mediation because they are risk averse. They prefer controversies to be settled by them rather than be decided for them by someone else. Compared to litigated divorces, research suggests that mediation encourages parents to comply with divorce agreements, remain involved in their children's lives, and renegotiate relationships in a more adaptive way. So what do people feel about these alternatives? What are their beliefs? Participants favored options that offered them control, so a neutral third party helping disputants arrive at their own resolutions, and processes that allow disputants to control their own presentation of evidence. Oh, one more quick thing here is that attorneys like the process, believing that it's fair and saves clients time and money. However, mandatory ADR can lead to the unintended effect, where some lawyers file meritless claims, and their claims will have settlement value in mediation. So there are community alternatives to standard prosecution. There is the sequential intercept model. And Muniz and Griffin came up with this in 2006. And this identifies 5 stages of the criminal justice process at which standard steps could be interrupted and a community treatment alternative suggested or substituted. So law enforcement and emergency services, post-arrest, so initial detention and initial hearings and pretrial services, post-initial hearings, so jail and prison, courts, forensic evaluations and commitments, for re-entry from jails, prisons, and forensic hospitalizations, and community corrections and community support. And we're going to talk very briefly about the first 3 stages. So we talked about crisis intervention teams before. Another offer here is the problem-solving courts. Lots of options there. And we've talked about these before as well. So just a reminder, we covered these in a lecture much more comprehensively before, but the problem-solving courts that are available are the drug courts, where you use drug convictions and you try to help the person get over their addiction rather than treating it as a criminal charge. There's mental health courts that help after deinstitutionalization, and you really try to get the person help again rather than sending them out through the system. Homelessness courts, again, focus on marginalized individuals and the underlying problems that result in homelessness. Community courts are a neighborhood-focused court designed to address local problems like vandalism, prostitution, shoplifting, vagrancy. Participants generally like how they're treated in these courts. And then there's veterans courts, where the district attorney may defer prosecution or offer a plea bargain at a reduced charge when it's clear that it was related, for example, to the veteran's PTSD. And again, we covered these at the beginning of the semester, but just a reminder of what all exists. Finley has been very active in these last couple lectures, so I thought that she should jump in here and say goodbye to you guys. Hope that you have enjoyed this lecture, and I look forward to seeing your assignments about what you think about the Stanford Prison Experiment. All right, thanks, guys.